what is legal and not legal in regards to, we'll just use this Coke can again.
Yeah, this Coke can's a best example.
Yeah, so if I'm a Coke competitor, I'm Cub Cola.
Yeah, correct. So
I'm
Cub Cola,
Yep.
first of all, it's about the brand.
Yeah.
Right? So Coca-Cola has a trademark registration for its Coca-Cola name. It has a registration for that logo.
Mm-hmm.
So that'd be two separate registrations. It probably doesn't have a registration for no sugar because that's a descriptor, right? So the difference is you can't own words that other traders need to use. So Cub Cola, if it doesn't have sugar.
You can't own Cub Cola no sugar. Or you can own Cub Cola but not the no sugar part.
Correct. So you could never stop someone else using no sugar.
But what about Zero, Coke Zero?
Well, funnily enough, I used to drink Coke Zero, but apparently 1 in 2 Australians didn't understand that the zero meant zero sugar. And that's why they had to change the name.
So there's no Coke Zero anymore?
Yeah, welcome. Yeah, welcome to the future. Coke Zero is gone.
It's Coke no sugar now.
Correct. And the reason why, I tell you this is true.
But it's the same brand. It's the same like black because you know how it's got the black.
Yeah, it's black. Yeah. It's a different formula. I'm telling you, 1 in 2 Australians did not understand that Coke Zero had zero sugar. 1 in 2.
That's why they changed it.
That's why they changed it.
Well, I mean, it does say what it. It's more descriptive.
I would have thought it wasn't hard to understand, but I don't want to say that. So the second thing about this Coke can that you need to understand is the shape of it.
Mm-hmm.
So Coke, you'll see the bottle there. Coke owns the shape of that bottle, the iconic Coke bottle shape.
That traditional glass Coca-Cola
Correct.
bottle that you'd crack open up on a hot day.
Correct. That's owned by Coke.
Around the family, around people you love, enjoying yourself.
Exactly. So that's owned. Whereas the can, I think every can's the same, right? But let's say Coke made a brand new can that was a pyramid. They would go off and register that pyramid, and then no one else, Cub Cola, could not use that pyramid.
So why do all of these soft drink brands have cans that are the same shape? Why didn't Coke trademark this can?
Because shape? I think you'll find the packaging. So the packaging people, whoever does the packaging for the cans, I think it's cheaper for the beverage community to have a standard sized can.
And therefore increase their profits. They're willing to make their cans the same in order to increase profits across the industry.
So I don't know that answer, but that would be what I would assume.
That's what you would assume.
You would only go a proprietary shape bottle costs more.
But I think that's really interesting what you said. Well, that's probably why, because the manufacturer of the cans can produce them much cheaper if they all have the same cans.
Correct. And isn't that the same shape as a beer can?
How funny.
I assume that every can in Australia is the same.
Yeah.
So if you go to IP Australia's website, you can see who's registered.
Because it's a scary thing, because it's almost like you, as a early stage business, you don't do it straight away because you're like, well, I don't even know if this business is successful yet. And also, you don't have money. So your money's going towards things. And then you get more successful and more successful. And suddenly you're like, oh, shit, my brand actually means something.
Yeah. So this is where I'll stop you and say that's not what I recommend. So the registration of your trademark for your brand at the start is a business expense, which if you got me to do it is say $2,000, right? Yep. And if in 3 years' time, when you become a bigger business and you have more money to spend, if you get a letter of demand from BHP, I'll just say, a global big company.
Yeah. Big scary
company, yep. Nike, whoever, big company says, look here, little chap, you're using my trademark, change your name now, and they've got a registration and you didn't bother checking, you're infringing. You're going to have to change your name.
Could they sue you?
Yes, they could sue.
And that. So you could get sued, but they're not going to. It's not worth the money spent to.
Well, it depends, Daniel. It depends if they think your business is impacting on their business sufficiently. So, I mean, I act for a lot of big companies that do write letters of demand to very small companies. Like,
just change your name.
Correct. Like the Cub membership is full of small businesses that could receive a letter from someone like me saying you've registered this company and you've started your own marketing business called Wolf, and we are Mr. Wolf, and we're going to come after you. And the usual letter of demand will say, change your name within 7 days and we'll do nothing more about it. Because as you said, you're not going to start an infringement proceeding.
If the
Most
people
people
don't
just-
have any money anyway,
Correct.
it's not worth you spending the money to.
Correct. 99 times out of 100, the little business goes, oh my God, I didn't know, and they change their name. But that's a hassle for that business.
Yeah.
They have to change their website, their social
Potentially
media
logo.
handles, their logo, their business cards, their whatever, their collateral. So if they have a physical presence, they need to change their signage. So you may not need to register your trademark on day one, but you at least need to make sure that you're not infringing from day one. And so to explain to the listeners, there are 45 classes of goods and services, and therefore IP Australia will register your trademark against a certain class. So someone else could register Cub if they were doing a musical instrument.
So like Cub guitars.
Cub guitars.
That's fine.
That's fine. So that's got no problems. And in fact, it'd be no secret to anyone that there's another very, very big business in Australia called CUB. Now, that doesn't do membership services and business-to-business services. It does beer. Therefore, it can do beer. We can do what we do. Cub Guitars could do what it does. Cub Fertilizers could do what it does. So there could be 4, 5, 10 businesses all with the same name.
Imagine if Cub wasn't done now and we had built this big brand, we've got it's got value. Someone could have technically, like let's say a competitor could have technically have come in, quickly purchased the trademark, started using our name. Could that happen? And then tell us, hey, stop using the name.
So the rules about trademark are different than business names and domain names, because the rule is who is the first to use the trademark is the rightful owner of the mark, as opposed to first to register. But if they went on the register before we did, we would have had a hassle in getting it registered.
Okay, so the government has, or the law has, also taken into consideration. Wait a second, we don't want to reward the scumbags that quickly
Correct.
go by the register a name that's unregistered.
Correct. So that happens in China because China is first to file. And so if our members are thinking about China as one example, China is a first to file, not a first to use jurisdiction. And that means if you go over there and register Apple as a trademark in Class 9 for phones before Apple does, Apple effectively has to buy back its trademark. There's been 2 million trademarks filed in Australia since Federation. There were 9 million filed in China last year.
Wow.
So members who are thinking about China and overseas need to understand that while common law countries have first to use, like we do, other countries have first to file. And then the scumbags come in.
And they sell you back the thing that you...
Correct.
They sell you back your own name to trade in that company, trade into that country.
Correct. There's an asterisk there. There's a bad faith registration requirement, but basically there's extortion.